Welcome to Talking Point. Tonight, we are discussing the proposed changes to the Criminal Procedure Code. One important aspect is in the shift away from jailing a person convicted of minor offences to getting him to do community work. Another is to let the prosecution compound certain offences, such as assault and mischief, into fines. How will these proposals affect the rule of justice here? What do they say of the prosecution of offences here? To answer these and other questions, we have with us tonight Mr. Anand Nalachandran, a partner at Alban, Tay, Mathani and De Silva, who has been practicing criminal law for about 10 years, and Reverend Sam Kuna, the Executive Director of Teen Challenge. Sam has been involved in programs and services for those with issues on juvenile delinquency. Now, let's start with you, Anand. These changes to the Criminal Procedure Code really is a movement towards a kind of a gentler, softer, kinder justice system, I presume. Now, does this really go to achieve that from your point of view?
Well, I think if you look at the proposed amendments from a macro level, I think two of the main things that stand out are the enhanced discovery provisions for summary trials, as well as the proposed options for community-based sentencing. I think any defense lawyer will always welcome as much discovery as possible in all cases. And for community-based sentencing, these are still being considered and assessed, but any option which gives the court more opportunity to find a sentence that suits the offence and the offender is always welcome.
Okay. Sam, you have been dealing with youth offenders. In what way will this help you in your work and in dealing with juvenile delinquency, for example?
The provisions for community-based sentencing, I think, has been enhanced. What I'm really excited about is that it will help to make our society, I feel, more humane in the treatment of first-time offenders who there may be other issues related to their criminal behavior that I think can be surfaced, and when those things are surfaced, then they won't be caught in the cracks and be unnecessarily sentenced into prison. But there can be other treatment options, especially for those that have emotional, psychological or psychiatric conditions. Then one particular provision I think that I'm really excited about is the mandatory treatment options.
What are these mandatory options?
I think especially for those first-time offenders or those that have undiagnosed conditions that surface as a result of their crime, then the courts then have the option to consider treatment for them, because part of the contribution to their behavior, their negative behavior, has not been identified previously. And so this, whether they have an IQ problem or whether they have early childhood onset of certain psychiatric conditions, then these are the ones who sometimes get caught in the cracks.
How different is this community-based, you want to call it sentencing, for example? How different is this from the corrective work order, where litter bugs are asked to go and pick up litter?
Okay, that's a very important point to differentiate. The corrective work order is really it's a punishment. It's a very light punishment, and also there is a shame-based element in the corrective work order. Whereas the mandatory treatment order, treatment for the individual, there's recognition that this individual has issues that can be treated.
And so these treatment will be outside the public eye, is that?
Not necessary. I think there will be transparency in every step and every decision made by the courts. But it will be...
What I meant was that when they serve the so-called punishment, it will be outside the public domain. Is that part of the...
well, I mean, if I can just take Sam's point on this, The mandatory treatment order is actually something which will allow the court to make an accused, an offender, go through psychiatric treatment if necessary, if appropriate, because that's going to be the only long-term solution to the problem. Otherwise, without this, which we don't have now, what you have is an offender who could have a mental problem or mental condition who can only be sentenced to a certain number of options. And sometimes a jail term or a fine is a short-term measure and won't really solve the problem, because after he served his time in prison or paid his fine, the problem still persists. The mental condition is still there.
Can I just move on to a different part of the CPC, and that is on confession statements or witnesses, giving statements to the police during investigation. Lawyers have been kind of asking that their presence, or at least the defense lawyer's presence, to be there during the confession or taking of a confession statement. Is that being addressed in the new CPC?
Well, based on what we've seen so far in the proposed bill, there's no provision that allows lawyers to be present when an accused person or a witness gives a statement to the police at present. That's something which we, at the criminal bar, have been asking for some time, because this, I think, would serve, several purposes. One very straightforward one would be, if a lawyer is there when the statement is being recorded, he can firstly advise you as to what your rights are, and secondly, he can advise you as to what your defenses are, and thirdly, if a lawyer is present during the recording of a statement, then there can be no allegation later on that the statement was involuntary.
So that means that is not being addressed in the CPC at all this time around?
Not that we've seen, no.
Can I just move on to another one, and that is about prosecution, and there is a very interesting word, frivolous prosecutions. And if you can prove frivolous prosecutions, then you can be compensated, the person who has been charged. The question I really have is, what do you mean by frivolity? Is it ever possible to prove frivolous prosecution? One, and it's unlikely ever a frivolous prosecution will happen. Do you see this as something that will change things, or is it just being put there as a matter of fact?
Well, perhaps only time will tell, but quite frankly, I would hope that no prosecution is ever frivolous or vexatious. That's my hope. So
the words are frivolous and vexatious, right?
Yeah. Correct. So I would hope that no prosecution is ever going to be frivolous or vexatious.
What's the point of this proposed change?
Well, at least allows the accused person an option, if in the event there is one. But personally, I hope that there never is one.
Can I, for both of you, now that the government has asked for feedback until February the 5th, what would be the things that, Sam, you would want to see in the more than what have already been proposed? What is it that you want to see?
Yeah, I would like to see a broader category than just psychiatric, because there are all,
when you mean broader category, what is that?
Okay, I also see developmental issues that affect behavior, and these are sometimes not detected because they may not be classified as...
Can you give one example?
For example, if the kid has gone through a certain trauma in the family, let's say had a massive accident, which I have encountered, and then a certain member of the family passed away. So there's some trauma that has not been treated. And that person goes through childhood depressed, lonely.
So you would like that included?
Yeah, because sometimes it may not be classified as a mental health disorder.
Alan, what's your wish list?
It's a long wish list. I think as any defense lawyer will give you many things that we'd want.
Just give me two.
Two, okay. If you have to pin me down to two things that I'd like. One would be for, witness statements to be provided to the defense for the conduct of summary trials in the
Second one?
District courts and magistrates courts. And, secondly, I think we talk about the compounding of offences. I think that more offences should be left within the discretion of the victim and the accused person to resolve among themselves.